our client approached the Federal High Court to determine whether Section 84, subsection 12, when read together with Sections 66, 107, 137, 182 of the Constitution, is not inconsistent. Now, the court agreed with our submissions, and it has just ordered that Section 84, subsection 12 of the Electoral Act is inconsistent with the rights of Nigerian citizens when read with Section 66 of the Constitution, 107, 137, 182, and now nullified Section 84, subsection 12 of the Electoral Act. And as equally has ordered the Attorney General of the Federation to delete Section 84, subsection 12 of the Electoral Act forthwith. Now, the implication of this is that it has provided a congenial atmosphere for politicking and political space for 2023.
The interpretation of Section 84.12, which the court has graciously put to rest now, as being a total nullity, being in conflict with the provisions of the Constitution. And originally, we honestly believed that it was inadvertence on the part of the National Assembly. It was a big error. And being gentlemen and distinguished senators and the members of the House, I think they will now go back and do the right thing, since the court has made pronouncement on it, and that put to rest every other issue with regards to that, so that we can move on with the national issues that are besieging us as a country and as a nation. So we don't have to be bogged down on the needless technicalities.
Let's help you make sense of some of the issues that have been raised over time by that provision. Professor Paul Ananaba joins us this morning virtually from Lagos. He is a senior advocate of Nigeria, as well as Sebastian Horn, also a constitutional lawyer and senior advocate of Nigeria. Gentlemen, thank you for joining us this morning. Let me begin with you, Prof. Many people are asking all kinds of questions. And for those who are unschooled about the law, so many sections are being thrown for and against. Help us make sense of it. What exactly is the issue here?
Well, we begin from where I think I understand it. The Section 6 of the Constitution empowers the judiciary to interpret laws. And by that Section 6, to avoid use of force, if you are unhappy with the legislation, you approach the courts. I guess that's what happened here. However, the court, let me make a point also here that this is not a case of a bill. It has become an act of parliament. So a court, Federal High Court, has powers to determine whether a law validly made by the National Assembly is inconsistent with the Constitution by virtue of Section 113 of the Constitution. That having been said, if you take the decision of the court and look at it, the court is saying that Section 84.12 contravenes Section 66, 1F, 107, 1F, 137, 1F, and 182, 1F. That is where the issue is. Sections 66, the sections are because it will bother Nigerians. I don't want to bother Nigerians about it. What that is saying is, if you're going to run primaries and party congresses, and you are a political appointee, you have to resign. Now the court is saying that is inconsistent with the Constitution, which those sections 66 and all that I've just read out, those sections say if you are in the public service of the Federation and you want to contest an election for Senate or House of Reps or House of Assembly, you need to resign 30 days before the time. So the court came to the conclusion that, okay, the Constitution only provides for 30 days, you will resign before the election itself. So Section 84 now is inconsistent. That is what the issue is.
Okay,
now, my position is, yeah.
Okay, go ahead.
My position is just simple. Section 66, 1F, 137, and 187 and all that talks about only limited positions of National Assembly elections. Now, it talks about those in public service also. So it has no way it contravenes Section 84, 12 contravenes Section 66 and all those sections that follow it. So I think that, yes, the court had the right, it had made this pronouncement. It's also subject of appeal, but I think I don't see any contravention. I rather see that the National Assembly members who have been players in this game all this while would have found out part of the problems of our democracy and have taken steps to block it. And I foresee that that will not be the right position of the law as we climb the ladder, as parties climb the ladder of the appellate process. I think that 8412 was well made, and it should be allowed to stand. Thank you.
Okay, all right. Honorable, beg your pardon. Mr. Horn, do you agree?
Yes, I agree with him. I agree with him that Section 84, Sub 12 of the Electoral Act is constitutional. And I vehemently disagree that it's unconstitutional. First of all, Section 4, subsections 1 and 2 imbues the National Assembly with constitutional powers to make legislation for the peace, order, and good government of Nigeria, in accordance with the exclusive legislative list. Now, if you look at item 22 on that list, elections are included, apart from local government council elections. So this piece of legislation is meant to enthrone order, peace, and good government of the Federation or any part of Nigeria. And if you also look at sections 66 1F, 102 1F, 137 1J, and 182 1F of the Constitution, those limitations do not apply to the scenario here. They are talking of a person shall not be qualified to contest election. Contest election. Now, Section 8462, to limit the rights of certain persons holding political offices from preparing for elections or engaging in pre-election matters. If you look at Section 285, subsection 14 of the Constitution, the definition of pre-election is broadly given there. And the Constitution has said that pre-election means congresses or conventions to bring in candidates and also preparations for elections. So these are two different things. We have pre-election and post-election. Now, if you also read Section 31, subsections 5 and 6 of the Electoral Act 2010 as amended, now repealed and reenacted, but even the 2022 version has just slightly amended that version of 2010. If you read those provisions and the long line of cases decided by the Supreme Court, Any person who feels that a candidate has supplied a false information in an affidavit can approach the court, and the court will disqualify that person if it finds out that that candidate did that. In a long list of cases, the Supreme Court has held that this is a pre-election disputation. And if we go down memory lane, we discover that the David Leon, the then governor-elect of Bayelsa State, became disqualified by the Supreme Court because his deputy was proved to have supplied forged documents. So I do not see the reason why anybody will be trying to mix pre-election and post-election issues and then trying to rope in sections 66, 102, 137, and 182.1 with their subparagraphs into what is clearly a pre-election issue. Because the Constitution recognizes the power of the National Assembly to make laws for the good peace, for the peace, good, and orderliness of the Federation. And this piece of legislation is in accordance with item 22 of the schedule, the exclusive list to the Constitution. So, and a similar legislation have been upheld by the Supreme Court. I just cited one now, which is section 31, which was section 31, sub 5 and 6 of the same Electoral Act, which also imposed a disqualifying provision. Yet the Supreme Court upheld it in several decisions, not less than 6 or 8 decisions. So initially, this is my take, but I can go on and on.
Well, we'll get to that part, Mr. Hon. Just let's track back a bit and still analyze this case now, this particular case, especially the process, because for a lot of people, it came out of the blues. I mean, the National Assembly had barely rejected the president's request to have that section 8412 deleted from the Electoral Act 2022. Just a few days after, I mean, there was still conversation around what will go on. The Attorney General also saying, well, they have a few options before their table. And then this judgment came just towards the end of last week. So it will seem both of you agree that, well, it doesn't quite contradict the provisions in 66 and others of the Constitution. But let's talk about the process of this particular case. And I'd like to begin with Professor Ananaba. So, the plaintiff approached the court, as I mean, it's been reported that the plaintiff approached the court to seek interpretation of the Constitution or that particular provision, as it were. And for a lot of people, it is curious that maybe the National Assembly, INEC, and some other concerned parties are not, parties to that particular suit. So how does interpretation of the Constitution, or in this case, how does it work? Should they have been a party to the case, or it could have just happened without their knowledge, and we got to this point where we are right now?
Okay, thank you. It's also been established by a long line of decisions of the Supreme Court that every action against the government, the Attorney General is the necessary party to sue. So if the Attorney General is sued, it is sufficient generally. But in this particular matter that touches on election, I would have thought that the court would have ordered that the INEC, even if they are not a party, should be put on notice, and so that this matter the court can have the benefit of more arguments. Now that the National Assembly also, of course, they have made the law and it is assented to. They don't necessarily have to be a party, but INEC. But having said that, there was sufficient evidence before that court to know that these are Section 66 and all that are talking about a different scenario entirely, as my brother had just said. And even if the court voids that provision, rightly or wrongly, the court couldn't have gone to a point of saying delete repeal. Repealing of legislation as a draftsman, I know that it's a legislative act. You know, it's a legislative act. Again, political appointees are not really, they are not public servants as such. I hope you know what, let's even move it a bit out of ordinary arguments alone. And so you can understand why that section 84.12 shouldn't be tampered with. A governor may appoint 400 special advisors and assistants and all that. And then they become automatic delegates. What will be left of that primary selection? That is what is at play, so that Nigerians can understand what it is. So all you need to do is appoint as many special advisors as other, and before the race starts, a governor's candidate, maybe the president's preferred candidate, is already miles ahead of you. So, and these are the reasons why we don't have much development, because these people are paid from government funds.
But Prof, just on that same issue, my sincere apologies for butting in, but on that same issue, you've tried to help us establish who a political appointee is. But in what section of the Constitution is a political appointee recognized? The definitions in section 318, for instance, I was looking for it. Okay.
Section 318 is very clear that they are not political appointees. And you know the cases of Asogwa and Chukwu and all that. They are there. The court has formally said political appointees are not they are not public servants in the sense of what is being discussed. And they are not guided by public service rules, civil service rules. They don't take civil service exam for promotions and all that, anonymity and all that. Now, the point by and large is that section 84.12 should be allowed to stand. That's so beneficial to this country. If it stands, we would have made progress in our political work. But if we begin to pull down things that are peculiar to our political experience, that will help us to make the right steps forward, then it is sad. I think that the appellate courts will review this type of interpretation.
Okay, let me go back to Mr. Hon, because I recall when the president sought for the review or the removal of that section, the sections of the Constitution he quoted was, I think, 40 and 42, saying that this would, it contains inhibitions and restrictions referred to under sections 40 and 42 of the 1999 Constitution as amended. That's for 7 political office holders. But the court in its judgment referred specifically to sections 66, sections 107, 137, and 182, which is, quite different. But still going back to the process of this particular case, it's quite curious that, a plaintiff approaches the court to interpret that particular section, and the only other representative we had was a counsel to the federal government, whose position we know is that, this particular section should be removed. So isn't it tilted to one side still? And I'd like to get your views on that as well. How would you describe that particular, angle of this case? That's for Mr. Hon, by the way.
Yes, I was worried because for the first time in the history of my watching, for the first time in the history of my watching court proceedings, television shows, both counsel for the plaintiff and the counsel for the attorney general were towing the same line. I was wondering, because you came to court for interpretation and you were expressing satisfaction when the court refused to accede to what you came for. And also, the counsel for the Attorney General was also excited. So it gives me some boost impulse, but I said no more. Now, having said that, I do not think that the president's arguments, with due respect to him, to his exalted office, are tenable. Now, why do I say so? A similar situation arose in Kenya, and the Elections Act of 2011 had a similar provision, like Section 84, sub 12 of our Electoral Act. Now, the Attorney General was not pleased. He went to court for interpretation. And the lower court agreed with him and struck down that similar provision. The Public Service Commission of Kenya went to court and reversed that decision. And in fact, the Court of Appeal of Kenya held that it's an abuse of public office for you to stay in power as a political appointee and then still be canvassing for votes. Because, they say, that court also said that decision was handed down in February 2022, around the 7th or 8th of this year, or February this year. So it is a current decision. If a smaller democracy like Kenya can be bold enough to tell the Attorney General that what you are doing is wrong, I wonder why the courts in Nigeria shouldn't do that. Because there is that distinction. Section 318 has defined who a public servant is. And let's also let's interrogate this issue further. If you look at sections 147, Section 147 of the Constitution empowers the president to appoint ministers. And then Section 171 also empowers him to appoint certain political office holders. Mark you, the word there is appoint, not employ. Section 66, sub 1F, and the rest that they're referring to, makes provision for employment, anybody employed in the public service. So how can these two be married? Now, the law is well settled by the Supreme Court and the Court of Appeal of Nigeria that when a phrase or a word has been defined with the use of the word means, for instance, they say this paper or this television means so. That definition is hard and fast. It does not admit of any other definition.
Ask you, Mr. Horn. Just 1 second, Mr. Horn. Just 1 second. If I can ask you, is there a provision of the law or the Constitution that empowers the judiciary to review law made by the National Assembly?
Very well. Section 1, subsection 1 of the Constitution makes the Constitution supreme. And then section 1, subsection 3 empowers the courts to strike down any provision that is offensive to any part of the Constitution. That is also replicated in section 4, subsection 8 of the same Constitution. But in striking down, you don't just go out striking down each and every legislation.
Okay, in the event, just a minute, in the event that, the judiciary finds such a provision of the law contravening the Constitution, what's the process of reversing it?
No, the process is for somebody to go to court, and then the judiciary will strike it down. But when
the strike down is done, how is it to be effected?
Well, you see, and that is another worry for me, because for the first time, I'm hearing that the Learned Attorney General of the Federation says he's going to gazette what has been struck down. With due respect to the Honorable Attorney General of the Federation, this procedure is not correct.
Okay, let's listen. Okay, just 1 second. There is this other opinion that I'd like Professor Ananaba to respond to. It is by a fellow SAN such as you, Chief Michael Zekome.
When the National Assembly was making Section 84, subsection 12 in the amended Electoral Act, by saying all political appointees shall not partake, shall not vote or be voted for at congresses or political parties, it was acting ultra vires. Because the Constitution in section 65, 66, 175, 176, 182, 183 has already told us who can contest elections or who is disqualified from contesting elections. So the National Assembly cannot add or subtract. The court has spoken and it is finished. It is finished. Once the court has spoken, except the people, the defendants in that case, appeal the judgment, and the Court of Appeal sets aside that judgment, and it further goes to the Supreme Court, the final Court of Appeal, and it sets it aside. That judgment remains extant, subsisting, valid, and constitutional.
Your perspective, Professor Ananaba?
Yeah, I agree with my brother in certain areas, but largely in some many areas I don't agree. Now, I agree that the court can make pronouncements, which we've canvassed already, Section 6, Section 1 of the Constitution. I hope that many people who argue this issue realize that we are talking about constitution to constitution. Now, the point has been made earlier in this program now. The Section 66, 107, and all that are talking about employees. Section 8412 is talking about political appointees. And employment in the public service carries certain public service character. Now, the court, if decisions like Dada Nade and Asogwan and Chukwu and all that had been cited before that court, perhaps that court will not have come to the same decision it came to. What is being said here is not about, you were alluding to Section 40 and all that. Those are fundamental rights provisions of Chapter 4. They are not even, they are not absolute. Now, to begin to say that the court is right or wrong, it's not what we can do in the media.
Okay.
We are only saying that if you look at the judgment, when was this act signed into law? February 25th. We are not even into March 25th.
Okay.
And
well,
there is so much. There is so much. Just 1 minute.
Okay.
There is so much of, okay, we are going to Gazette. We are going to challenge it in court. We're going to Gazette. The appellate process has not gone through. Before you stop me, let me raise one scenario that is very important.
You will raise that scenario. Just a second, Prof. You will raise that scenario when we return from this break. Please stay with us. Thanks for staying with us. Professor Ananaba, you were trying to set a scenario earlier.
Yes, the scenario I'm going to set is, what if a political party now relies on this interpretation, goes for a conference or a convention, and allows political appointees to participate and vote, and after voting, the appellate courts return Section 8412. What will happen to the conference, to the convention? What will happen to the process? So I think that as we march through this political process, both the bench and the bar should be wary what role we play, what interpretations are given, because the court is the last hope of the common man. Like my brother said, a judgment is given in a very landmark case like this. The defense counsel is jubilant. that he lost. I don't know how it looks like, but you know that that's not the traditional role of the defendant. The defendant has not even consulted his client for even these celebrations. But what I want to say going forward is that we will look at what happens in the days coming. The National Assembly, if they feel very strongly, can appeal as an interested party. INEC can. These are part of the areas where INEC should show independence, because some of these decisions now are beginning to affect their preparation for the elections.
But, well, Prof, you know, those issues are endless, certainly, and we'll get into those as we go along. But there's another legal practitioner that's just joined us now, and that is Monday Ubani, who is chairman, NBA Spittle. He joins us via phone. Thanks for joining us this morning, Mr. Ubani. Well, this is an issue that certainly interests you because you have commented on it already, but the arguments are endless. The definition, for instance, of political appointee is not explicit in the Constitution.
And that is correct. And that is correct. And then there is a judicial pronouncement by the Court of Appeal which says that political appointee is not within the definition of a public servant that requires even to resign 30 days to the election. If you remember the case of Shegu Oni and versus Fayemi, the Court of Appeal affirmed the decision of the lower court, excluding political appointees as those who are bound to resign prior to election. And that judicial precedent has not been disturbed by any appellate court up to this point in time. The position is this, Ayo, concerning this present matter. I have argued through my article that went viral that I'm totally in agreement that that particular section is at variance with the provisions of the Constitution. My only problem is the method.
What part of that provision is at variance with what part of the Constitution?
Beautiful. The Constitution, let's even assume that the correct position of the law is that the public servant should resign 30 days before election. Let's assume that is the correct position, and that political appointee falls within the definition of a public servant. If the Constitution says you have to resign 30 days to election, will it be right for another law that is clearly inconsistent with that provision now says you have to probably resign several months before the election? Is that not an inconsistency in the Constitution? If the Constitution says, you know, this is how many days we have to resign, and then an enactment of the National Assembly now
the provision, Mr. Ubani, just 1 second. The provision, just a second, Mr. Ubani. The provision in the Constitution talks about public office holders, no, beg your pardon, public servants, not political appointees as stated by this contentious clause in the Electoral Act.
Yes, that is one aspect of the inconsistency I was referring to. Now, the issue of discriminatory law that is meant to discriminate among political office holders. Now, if you remember that section says National Assembly members, legislators, governors will still remain in their office and contest and vote for. But the political appointee that is appointed should resign several months before the election. And the argument of people is that, look, elected officers have tenured appointment. I'm saying that political appointees are appointed by an elected officer. A governor appoints a political officer, a political appointee. And that person happens to be his own candidate he wants to run an office with. And you are now asking that person to be removed from an office when the political appointee, an appointer, has not removed him. You are going against the political appointer that is also elected. Remember that he has appointed this individual to run an office with, to help him actualize his political objective. And you are now using a law to drive away this individual, contrary to the express intention of the political appointer, because he is also elected. Because if the argument is, National Assembly members are elected, and so they have tenure position, one of the political appointer that is also elected, they have now selected this individual to help him actualize his objective. You are not asking him to go leave office before even the appointer, before the time the appointer will ask him to leave office. So I am months before the election, it's clearly discriminatory. But allowing the person who is elected to remain in office, vote and be voted for, it is clearly discriminatory. A law that National Assembly cannot enact that is clearly inconsistent with the provisions of the Constitution, which is the ground law.
Well,
that
some will say that you can also...
And then there are several other arguments.
Mr. Bani, if I may come in now... pardon me, just a moment. Just on the point you made...
Several months before the election.
If you can hear me, Mr. Obani...
Months, which is what the court in Federal High Court, Maya has actually held.
Okay, just following up on one of the points you made, Mr. Obani, if you can hear me. I mean, some will say that argument can be made for, that provision in Section 66, which also says that no person shall be qualified for election to the Senate, House of Reps if he is a person employed in the public service of the Federation of any state. So essentially, it's removing the person from office before, the person fulfills the mandate, as it were, that the person was employed for. And I just want to ask you, practically speaking now, what do you think the Constitution was trying to cure when these provisions in sections 60, 66, 107, 137, 182, 1F were made? What was it trying to cure, saying you must resign 30 days before that election?
When you are in an office, you have some certain privileges and position that is attached to your office. And so I'm sure what the Constitution was trying to cure is to allow a level playing ground for every political aspirant. That the person who is in government or who is a public servant should not take undue advantage of his or her position in order to probably make it advantageous to him and put the other person in disadvantaged position. That is why the Constitution says you must resign.
Isn't that the same thing that Section 8412?
A level playing ground for everyone.
Right. Isn't that the same thing that Section 8412 of the Electoral Act 2022 is trying to cure as well?
No, but if it's asking you now to resign several months, that is the issue. If you look at that decision of the Federal High Court in Oman, it says, let it remain that the public servant will resign 30 days prior to the election. And so if it's 30 days prior to the election, it is correct. I don't have any issue with that. But you are not saying several months, contrary to the express intention of the appointer. Appointer has the reason for appointing that individual. You are not asking the person to live several months. And that is contrary to the appointer's intention.
Well, just to be clear, Mr. Obani, that particular act does not say several months.
If going by that particular act, all political appointees who want to contest election in 2023 should have resigned by sometime in March this year. They are all cut off. They are all cut off by the provision of that particular act. If you look at it very well, by now they ought to have resigned. If you are going to contest the election as a political appointee in 2023, by now you're supposed to have tendered your letter of resignation.
And so, the dates can differ. I think the dates will differ depending on when the party chooses to conduct, the convention and all of that. But specifically, that act does not say several months.
Most of the primaries is going to hold this year, sir. Most of the primaries is going to hold this year, and that will be several months prior to the election of 2023. Election is taking place in February next year, and most of the political parties will hold their primaries this year. And so you are asking the political appointee to leave office several months prior to the election of 2023, sir.
Okay, so let me take this. I just wanted to make it clear that several months is not specifically said in that law, but of course you can interpret it as that. But let me take this to Mr. Hon and get his perspective. So clearly Mr. Obani thinks that this is still in contravention of provisions in the Constitution. And he said, saying several months as opposed to 30 days is a bit too far. And I wonder, what do you think about this, seeing that a fellow legal practitioner, agrees with the provision?
Well, I totally disagree with him because in the first place, he posited that the provision is discriminatory. But when you confronted him with Section 66(1)(f), which says 30 days, the same objective is sought to be achieved, he now began to say something else. But well, I will not go further. What I will say is that the same morality that shouldn't allow somebody who is holding a political office as an appointee, and he's going to contest primaries with people who are not holding political offices, should be applied. It's a two-way traffic issue, because those ones are not holding any political office, then there should be a level playing ground. He's quoting level playing ground. Is it only for political appointees? So it's not discriminatory either. If you look at Section 45 of the Constitution justifies any law that is made for the public good of Nigeria. So, and I also quoted Section 4, subsections 1 and 2 of the same Constitution. The National Assembly has power to make law for the good of the country, the peace and good governance of the country. So now, if they decide to say that for a level playing ground, if you are a political appointee enjoying the perks of office, that alone is discriminatory. But we can't stop it. Then step aside some months, also come and canvass for votes, so that you get public support, not staying there and using your position. These similar arguments were canvassed in the case of Public Service of Kenya against the Attorney General of Kenya, which I referred to. February 7th, the Court of Appeal of Kenya upheld Section 43, subsection 5 of the Elections Act of 2011 of Kenya. Now, similar arguments that he advanced, that what of the members of the legislature who are now resigning? They can't resign. A similar provision, Section 43, subsection 6 of the Kenyan Law Act, rather, also exempted governors, National Assembly members, and other people from resigning. If we pursue the law that way, then we'll also be saying that that was discriminatory, but the Court of Appeal of Kenya said, no, it's not discriminatory. So what I'm saying is that this law is valid. A law can only be inconsistent with the Constitution if it's mutually exclusive of the Constitution. In fact, in that Kenyan decision, they said that there are some other provisions, just like in the Nigerian Constitution, that says you must resign some days to the election. So the Court of Appeal of Kenya held that that particular provision of the Electoral Act was made to assist those provisions to the Constitution.
Mr. Hon, there will be questions as to the propriety of the Kenyan case or Kenyan constitution in the case of Nigeria. I understand that you're trying to draw inference, but I mean, we're staying with the laws of Nigeria, so perhaps that should be the focus here, except we say that maybe we need to copy some of those provisions.
I have never left the laws of Nigeria.
All right.
My learned brother, Professor Nanaba, has cited at least three Supreme Court of Appeal decisions that say political appointees are not public servants. That should have answered this issue. He graciously said that if those authorities have been referred to the Federal High Court judge, perhaps a different decision would have been reached under the doctrines of judicial precedents and stare decisis.
Right.
Perhaps they were not raised, but if they were raised and sidetracked, then it's unfortunate, but I do not believe they would have been raised. Now, having said that, because time is running out, I want to address an issue that Michael Zekomo, my learned brother of the Inaba, raised, the doctrine of covering the field. Because time is running out, and Nigerians need to know, covering the field is not all-encompassing. In fact, covering the field is an 1842, it has an 1842 origin in Australia. It has been applied severally in Nigerian courts, including the Supreme Court of Nigeria. In 2013, it has two ends. One is that where the Constitution has covered a particular area, no other legislation should cover. Another aspect of it is that once a federal act, that is an act of the National Assembly, has covered a particular area, no state law should cover. So, but the principles are the same. In 2013, there was this decision of the Supreme Court appealed by the Attorney General of the Federation against the Attorney General of Lagos. Lagos State had enacted 3 laws to regulate hotels. And the Attorney General of the Federation challenged that provision, those provisions, and said that tourism under item 20 of the exclusive list belongs to the federal government. And therefore, the doctrine of covering the field excludes Lagos, or excluded Lagos, from making provisions for hotels. See how close hotels, hotel business and tourism are. The Supreme Court said no. The item 20 you are referring to did not cover the field, did not cover hotels. So no matter how close public servants are to political appointees in terms of definition, which I disagree, I don't concede. The two cannot be married together. I also am enamored.
Let me ask you, sir. Let me quickly ask you, sir. So it would seem that, Mr. Hon, if you can hear me, it would seem that you agree with Section 8412 as currently is in the Electoral Act. Well, we do not know if it's been deleted already. But I want to ask you, in the event that public officers have to political appointees have to resign to be able to participate in elections or conventions, what should happen to their seats when they go? Will the political appointer need to appoint people again who will go through another process for a few months just before an election or an electoral cycle? Wouldn't that be disadvantageous on the long run to a nation?
But you see, thank you for that question. You know, my sister, people change their cabinets 3 months to elections, or 3 months to when they're going. Nobody queries that. And that even emphasizes what we're saying here. Political appointees are hired and fired at the pleasure of the appointers. You can appoint a minister today, fire him tomorrow. This is different from a public servant, where we have laid down procedures for relinquishing them of their employment. So political appointments.
The question is that to the advantage of a country on the long run? That's the question I'm asking. I mean, given where we currently are, we know. Please go ahead, sir.
You see, yes. You see, we are just bringing. Well, with due respect, madam, I can answer yes or no. By the way, nobody has exclusive right to enjoy political office. You can be appointed. If you are nursing ambition to go to the next level, you vacate for another person. The other person is also a Nigerian. So everybody must enjoy the advantage or the privilege. You can't eat your cake and have it. And by the way, as I said, the appointing powers have also dismissal powers. So whether or not it's healthy, it's no more a legal issue. It's a moral question. As far as the law is concerned, you can appoint and fire, and if you can appoint and fire, the same person should not sit on that seat and canvass for votes, because he's eating his cake and having it to the disadvantage of other Nigerians. It's as simple as ABC, with due respect.
Let me ask Professor Ananaba what he makes, I mean, of that particular scenario, and whether or not he agrees that the Attorney General should be deleting. I mean, I know that people have also taken offense at the outcome of the judgment. Some people have said that they've never heard it before, that an Attorney General has been asked to delete sections of any law.
Yes,
have you heard that before?
Yeah, I speak clearly as a draftsman, a trained draftsman. Repealing the enactment of a piece of legislation is a legislative act. It's not a judicial act. So, as a legislative act, it's only the legislator that can repeal and reenact. The court can interpret and pronounce. The court ought to have stopped at pronouncing validity or invalidity of the act, and the other legislative and administrative acts takes place. So the issue of this is not a blanket provision in the Section 8412. It only says if you want to participate in the primaries, to stand and be voted for or to vote, resign. It doesn't say all political appointees should resign. It's a decision you choose, a choice you make. It's not discriminatory. What is rather discriminatory is what we have found ourselves in. How many Nigerians will say that what we have today as political culture is correct? Are we going to endorse what we have, or must we make progress? Why do we blame the National Assembly that they are not making good laws for the country, when they will make good laws and we will strike those laws down? What are we? Where are we headed to? the objections to Section 8412, are they born out of public interest? Are they born out of patriotism? Where is the objection coming from? That a law says, if you are a political appointee, which has been severally, in fact, a colleague cited Oni and Fayemi here. Oni and Fayemi is very clear. Oni and Fayemi doesn't even support the argument being put in favor of striking that 8412. He rather supports 8412. You know, so also is PDP, the PDP and INEC. So a minister,
Prof,
for example.
let me quickly pose some of the questions you have raised, Prof. Let me quickly pose it to Mr. Obani. I do not know if he's still with us. Mr. Obani, if you can hear, if you're still following the conversation, would you like to respond to some of the questions raised by Professor Ananaba, in whose interest is 8412 if it's deleted?
Well, if you can hear that, Mr. Obani is asking, in whose interest is Section 8412 to be deleted, in your opinion?
Yes, I must confess that I didn't hear a bit of the word of the learned sake because of the fact that I'm joining through telephone, so I didn't understand what he has just said. But the question you asked, in whose interest is Section 84? And that, I think, is in the interest of the country, generally, by the assumption of those who have enacted that particular law. When the president was raising a question to the constitutionality of that section, some of us did not see the wisdom at the point he was raising it, because we felt that the president himself did not raise that issue in the first time. There was a particular issue he raised with the issue of primaries, and that was corrected. So why didn't he raise this particular issue? So all of us were against the president, asked him to go ahead and sign the Electoral Act because of some of the innovative provision in that act. And so we didn't look at the wisdom at that point in time. But after the signature, people begin to look at the provision of that section and consider it whether it is clearly a fair section. It's not a popular opinion, necessarily, because some of the governors have abused the issue of political appointees, using it to their own political...
We're winding down now, but I just wanted to quickly put this through to you, if you can do in 30 seconds. It's a double-edged one, so maybe short answer. First, who's going to appeal this? Because the parties to the case seem to be okay with this particular judgment. And the second edge is, can the APC go ahead with its convention with a deleted Section 8412?
Yes, they can. For now, I don't know, any interested party. I think the National Assembly, is an interested party. I'm surprised they were not joining as a party. INEC should be a necessary party in this particular suit. So all of them at this juncture can come in, in the Court of Appeal as an interested party. They can appeal. And that's why I was surprised when the Attorney General, Honorable Attorney General, was saying that it's not going to be an appeal. He cannot conclude that because interested parties have a right under the law to appeal against that particular judgment. INEC and National Assembly, or any NGO, any NGO can come in as an interested party in this particular case in order to appeal against it. Now, it does not stop APC from going ahead with their primary, because for now, the position of the law is that that particular section is deleted. It's no longer in existence until it is turned in a Court of Appeal decision. Okay. The present position of the law is that that section now does not exist.
All right, Mr. Obani. Well, yes, thank you, gentlemen. I'm just wondering what's going to happen in Kaduna State now, where that memo already went out to political appointees. But for now, Sebastian Horn, Senior Advocate of Nigeria, Professor Paul Ananaba, Senior Advocate of Nigeria, and Monday Ubani, former second Vice President of the NBA. Gentlemen, thank you so much for your perspectives this morning on this issue.
Thank you.
You're welcome. Thank you.
Okay, yeah. So we're back right after now with another topic. It's on development. Please stay with us.